Okay, let me say good afternoon to members in the media. I called this press conference this afternoon because for, I guess maybe a lot of people don't know, I was actually on another period of vacation, so I was actually off last week when I was asked to make a comment, particularly about the World Gazette issue. I'm not the World Gazette, the KFC issue. And I'm here to clarify something that has been said. Particularly, I know that Mr. Golf Finnegan wrote this article in relationship to the KFC staff now have accepted contracts that they originally objected, right? Let me just be clear, because I think that, you know, what we tend to do from time to time is put half-truths out there. And I'll say this respectfully, I think that's what KFC have done. What the staff have accepted now is something completely different than what they accepted now. And you might say, well, how is it different? Last year, the staff were not offered redundancy pay. When KFC told the staff in December of 2011, and then again in May of 2012, they were offered employment with KFCO, but they were not offered redundancy pay in accordance with the CBA. They were not offered redundancy pay in accordance with the Employment Act. So based on that, for the employer now to say that the conditions that the staff now have accepted is the same conditions is utterly nonsense. It's not true. What the employer has done in May of 2013, and here's where you need to watch where things change. In May of 2013, the employer came and said, we're going to offer the staff employment at KFCO. Anyone who doesn't accept a job at KFCO will be paid redundancy pay in accordance with the collective bargaining agreement. And this statement was made in May of 2013. Now you see how things have changed. Complete difference. Because the company had not initially offered redundancy pay based on the CBA. They had not offered redundancy pay based on the Employment Act, which was something that, according even the Act says that if the Employment Act says that if you are going to make somebody's job redundant, then you have to offer them redundancy pay. The collective bargaining agreement also says the exact same thing. So I'm a bit surprised that some 13 or 14 months down the road, the employer now came back and said, you either take employment with KFC by, I think it was June 1st, 2013, or we're going to pay you severance pay in accordance with the collective bargaining agreement that they said was terminated, that doesn't exist anymore. They're going to pay on redundancy pay based on in line with the collective bargaining agreement. So I needed to get this matters clarified because it would appear that it's not been put out there. Because what has been put out there is the exact same conditions that were there in 2012 are now there in 2013, and that's utterly not true. Any questions?
So effectively they've accepted the collective bargaining agreement. In other words, they're abiding by the terms of what they said in terms of correct.
What the staff have accepted now, they have accepted to go to work on the KFCO and forego the redundancy pay based on the CBA. They had two choices. One choice is they could have accepted severance pay. The second choice is they could have accepted employment with KFCO. My understanding is the majority of staff have gone to work for KFCO because the employer has employment for them based on similar or better working there or based on similar conditions. They have accepted those conditions, so redundancy does not apply. But they did offer the redundancy provision. It was offered to all the staff that had not initially gone to work with KFCO.
So was the agreement that they made with KFC similar or the same to the collective bargaining agreement?
I'm not exactly sure what exists under the KFCO agreement. I know there are some conditions that exist under the KFCO agreement that speaks about certain leaves and those sort of things, but I would say that it's not I mean, normally what companies do have is a handbook that lays out exactly what their rights are. According to even the Employment Act 2000, the employee should have a statement of employment that says exactly what vacation time they're entitled to, what other benefits they're entitled to, should be laid out in a statement of employment. So even though they may not have a CBA, they should have a statement of employment that lays out all the benefits.
So they don't have a collective bargaining.
Under the KFCO, they do not have a collective bargaining agreement. No, they do not.
They have
KFCO operations out of KFC Bermuda. It's changed to the Bermuda to operations. Yeah.
So can we assume then that the staff at KFCO is now happy or they're not happy?
Well, let me just say this to you. I know we met with them a couple of times over the last 2 to 3 weeks or so, and they are upset. And one of the reasons why they are upset because, you know, what you're not going to hear from time to time is that the management have you believe that, everything is rosy down at KFC, or KFCB, whichever one you want to call it. We know for well that they fired 2 workers from down there. One of the workers they fired was the chief shop steward. Her name is June Douglas. She worked at KFC for over 30 years. It's an unblemished record. She is out on certified sick leave, and the employer terminated her employment. And KFC is a very fortunate company. I'm telling you that, very fortunate. Because had this been another place of employment, I can draw you an example. Look what happened down at Public Works the other day. They didn't fire somebody down there. They wanted to suspend this guy for 3 weeks for taking a government vehicle in. And the workers dropped tools for 3 days. Can you imagine if they fired the chief shop steward or the president who was off on certified sick leave? And the management has done this to the system and had no repercussions from the staff, none whatsoever. 2 weeks later, 3 weeks later, they fired one of the shop stewards, the night shop stewards. They fired her for insubordination. What happened to a warning? What happened to a suspension? They fired her. Why? Because she's too outspoken. See, these are the kind of things that management doing under that, I don't know how the staff on the KFC is going to tolerate that, but at some point in time, you got to say enough is enough.
When did this happen?
Ms. Douglas was fired on May 13, 2013. And the reason why I remember that so clearly because I had a government meeting the exact same day, and the General Secretary did have a meeting with Mr. Benavides, Carl Masters, our lawyer from Trout and Duncan, Ms. Burgess, and Ms. Douglas. They met on the 13th of May, and she was fired on the 13th of May, while she had a certified doc certificate. Certified doc certificate.
Why isn't it going any further?
Well, the matter is going further. It's done. I think it may be done at the Labor Department. I think we're also taking up the human rights or whatever. But this is an issue that shouldn't have to go this far. How do you put 35 years for an employer, have a certified doc certificate, and the employer fire you while you're off on certified sick leave? Well, I'm going to let you just ask yourself that question.
How many people did not accept the agreement?
I'm not sure, but it may be all about one, and I'm not sure whether it was 2, but I think it was about one person that was thinking about not accepting employment with KFCU, and probably took their redundancy money and left. All we said to them, based on and there's a lot of talk out there about who won what and all this kind of stuff, and I'm really sick and tired of people saying about the BIU loss. The BIU never lost. We won all the major courts in this in the court hearing. There were 2 courts that were split between the employer and the union. So for management to say that they won something they didn't win up, case number 212 was split between the employer and split between the union. So we both got that course. So I don't want people to think that we won the majority of our courts because we also won 188. So there were 2 actions taking place, 188 and 212. We won 188 and we won a portion of 212 and the employer won a portion of 212. And the majority of the case was in 188.
The fact that the workers,
yes,
did not respond to what you say is an unfair dismissal. What does that tell you about in terms of labor relations?
It doesn't say, Mr. Johnson, it doesn't say anything about the state of relations. All it says is that at that particular workplace, the workers decided that, they didn't feel that they needed to have any kind of industrial actions to support the chief shop steward. It's very unfortunate. But let me just say to Bermuda that that's not going to happen at every workplace. It will not happen at every workplace.
Are you disappointed with those workers?
Extremely disappointed, sir. Extremely.
I would like to understand that the workers, after communicating with the lawyer, had decided that rather than going to all this stuff, they wanted to keep their jobs. They decided to accept. Was that capitulation, or was that just understanding the dynamics? Well,
let's just be clear, Mr. Webb, exactly what happened, because I was in that same meeting. And basically what happened is that, when the goalposts shifted, when you look at what happened last year, the employer did not offer any redundancy pay to the staff. They were in violation of the law, Section 31, as relates to sham sale. And based on that, they must have taken some advice over the past 12 months. And in May of 2013, they came to the census and put the redundancy provision on the table. If they'd have put the redundancy provision on the table in 2012, I don't know exactly where we would have been today. But based on that, we knew that the workers were entitled to certain rights under the CBA. We knew the workers were entitled to certain rights under the Employment Act 2000. That if you're going to terminate my employment, I am entitled to severance pay. The employer never put that provision on the table until May 2013, which was some 12 to 13 months after they was telling the staff, you either go work for KFCU or you're not going to have a job. They never told the staff, go work for KFC, and we're going to pay you redundancy pay if you don't go, They never put that provision on the table before. And that has to be, I can't emphasize that enough, that provision was never put on the table in 2012. Never. It was only put on the table in May of 2013. Why? Because the employer recognized they made a huge mistake. Why? Because they offered the staff redundancy pay based on the CBA that they said was terminated. How do you now offer somebody something that you say was terminated? Huh? How you do that? Anyway. Any further questions? Thank you.